Yeah, good afternoon, everyone. My name is Professor Ehi Eric Esoimeme, Professor of Business Law and Ethics at James Hope University. Now, what I'm here to do is to do a pre-recorded class that details how students can address legal case studies. It's very important for that, because to take it step by step, and I will promise to make it short so that we're able to achieve that. We're also going to share some number of samples so that everyone is able to know how to practically address this question. So just to start with I'm already sharing my screen. Here, we have that part of the essays, addressing the essay questions, but for now, that's not what we are looking at. We're looking at the, legal case studies. And This case studies describe a factual situation which, on a closed legal scrutiny, raises a range of legal issues that need assessment and interpretation. So you will see those facts, and what you need to do is to actually raise a range of legal issues. And then one of the things that we see is that problem solving is very fundamental to law and the development of problem solving skills in the legal context. And so in approaching a case study, a position similar to that of a court judge is taken because the thing about it that some students mistakenly adopt an approach of as if they are actually the lawyers themselves. But when you're a lawyer, what you do is to do anything to defend your client as much as possible. So your position is likely to just be one-sided. But when you are, approaching a legal case study, what you are doing is you're adopting the approach of a court judge. The court judge looks at it from different angles. So you have different parties there looking at it from different angles. He's also looking at it from different point of views in terms of the law. So the question has to be answered is whether the law as it exists covers the situation before it. So that's what the judge is actually looking at. And as you can see, as we're sharing the screen, this is what the judge will do. The judge will isolate the material facts for the legal issues in question. The judge will construct the legal arguments and will deliver a verdict. This is how similar to that for you on your own. You have to isolate the material facts. When you see the particular case study, you need to isolate. There are some facts that are immaterial, and the material facts are what they call relevant facts. So you have to isolate that out, and then from there you now construct your legal arguments. From either side. Because, like I said, some people make the mistake of doing it from two sides. For example, you can have a situation where, if you're looking at it relating to negligence, for example, there's contributory negligence, there's negligence itself. Some people will just go for that of just negligence. You're supposed to, if there is a particular legal principle that has to be argued, you need to argue it in line with it, and because the aim of it is giving that legal advice. So for you to give the legal advice, you must first of all isolate those material facts and then construct possible legal arguments, and then from either side, and then advise that individual asserting the most persuasive argument for his or her benefits. And one of the things that happens is that there's a pre-stage, a pre-stage. This is before you even start stage one. We talked about that you have to adopt like the approach of the judge. But in this particular instance, before we even do that, just like we mentioned initially, one of the major things you need to do, is to know how to enter into the prestige, the prestige side, and this is where the material facts are being, identified. Very, very key to understand that the material facts have to be identified at this stage. Once you know what the material facts are, it makes it much easier for you, just like a judge. When the judge is assessing the facts of a case, the advisor must identify which facts are material to the legal problem at hand. In order to do this, you have to know who is seeking the legal advice. Is the advice specific to a cause of action? Could be a misrepresentation or something general contractual, or what a redress is the injured party seeking. So there are certain things that will guide you to know the material facts. Another important thing that will guide you to know the material facts is where stage one will go in. For example, because you are giving a legal advice, legal, whatever material facts you're identifying is tailored to a particular legal provision or principle. So it's not the material fact that is more of not required in the legal sense. It's not supposed to be something that you identify. So the first stage, so the pre-stage, like we said, is looking at what are the relevant facts. If you are maybe in an example, you're already making your notes that okay, these are likely the relevant facts that I'm actually need to consider. Then, so when you now look at those material, we're going to do a practical sum of that. So stage one goes to identify the relevant law. So as you have seen the particular case study, now it's now a little bit easy for you to say, okay, I have the material fact. Material fact is more like a personal note for you. However, as you can see in the how you answer the question, it will fall into the background of facts when you start answering it. We'll get to that. But in terms of the legal case study itself, the issues, you have a range of issues that you have to sift out. When you now sift out that issue, those issues are sifted out from those material facts. Remember, the pre-stage one is material facts. So when you are able to identify, okay, these are the material facts, which you could culminate into your background and facts. When you are, first of all, you do your introduction, you do background and facts. Then you now identify the issues. You take the issues one by one. You don't just lump them together and say, okay, I have some because of time. I say, okay, I've identified 5 issues. Then you start taking them one by one. So issue one, you apply all these stages to that particular issue because you want to give the person an advice. So that advice has to go in line. Now, if you have identified issue one, then under that particular issue, you identify the relevant law. Just like a legal essay, the strength of giving legal advice lies in part of the level and detail of legal principles that have been learned. So you have to identify the law. Which law are you looking at? Because case studies raise multiple areas of law to be considered. And these principles are set out in a clear and logical order. So it could be a law, maybe in terms of offer and acceptance or consideration, in terms of the invitation to trade, the difference between those parts of invitation to trade, like we know, could be invitation to trade could be like an advertisement. So the legal principle that connotes with that. And, that is exactly what it is. Then going further to define it itself, elaborate on it. Now you've been able to, you've identified that, okay, this is the relevant law itself. Then you have to define it, elaborate on the principle of law itself, and also support it with, the case itself. Many of them have case citations. So you support it, you define the law. The principle of law will also be that maybe acceptance by post. It has to be done, this is the particular way it's being done. So that is actually the principle. The principle of law says that once you do this, once you post it, the acceptance, then maybe you have accepted the offer. That's like the principle of law. Supporting it could be, in this particular case, this is exactly what the judge actually said. Then you now apply that relevant law to the material. Remember, you stated that material facts before. That is one of the reasons why you're sifting it out. The aim of it is that when you look at that case study, just begin to sift out those material facts as a first stage. When you now do that, you now be able to say, okay, I've already sifted out that. Let me now identify the law that is relevant. Then I now go for that, elaborate on it, then I now apply it to those material facts. It's very, very key that people see it in that particular way. So at this stage, the main objective of application, because some people, when they say application, it's almost as if you are marrying the law to the facts of the case. It's like somebody now that's talking about acceptance by post. You have to look at it critically. When you say acceptance by post, the facts of the case, that particular side, that fact of the case is tailored towards what you are actually saying. So in that particular case, you can say Gary, was able to, he actually received the offer on December 1st. He now went to the post office to post it on 2nd of December. So you are already marrying the law to the facts. And you can only do that with arguments and possibly counter argument. That is what they call applying relevant law to material facts, to finding the solutions. And then that's exactly where it is. Then with that, you can now talk about giving your advice within that particular parameters. So The pre-stage, like we said, is followed by the first stage process outlined above. Usually happens within each issue. It's not as if it's maybe separated. It happens within each issue and is programmed clearly done within each issue. So in most case studies, a limited range of facts normally be given. And consequently, we have a situation where there will be gaps which need to be filled. Sometimes this instance, you have case studies where they are incomplete case studies. So it's very important that you have to fill in the gap. You must ensure that you fill in that you kind of imply certain facts, but you must not go too far. You understand how the thing is. You must not, because once there are gaps, what you need to do now is your arguments now have to now tailor towards the, like, okay, if this was the situation, this could have been the case for it, the case law to address it. And if this was the situation, this could also have been the case law to address it. So that's exactly what it is about incomplete facts. So, and there was an example given, Gary advertised his car for sale with a newspaper, £5,000. Martin phoned Gary, I'll give you the £4,500. Gary said, okay, £4,750 was the lowest, was able to go. Martin said he would have to think about it and ask Gary to give him the first option of the sale. Gary agreed. A week later, Martin wrote to Gary accepting the offer, enclosing the building society check of £4,750. Martin now discovers that Gary has sold the car to someone else, advised Martin. So this is usually how it is being asked. Although we call this structured case study. We have some unstructured, we call this unstructured case study. The structured case study are the ones where the issues will already be identified for you. Questions, issues are like questions. They will come out and to be extracted. You don't have to start it as if for you a number of work has been done, but mostly in a kind of legal sense, this is usually the first step we see. So although not a separate part of the advice, the first issue to be addressed in any case study is identification of the material facts, like we said. By reading the earlier chapters, contract formation, as we did in the class, the facts here suggest that two areas of law are concerned. So with that, it gives you an idea. And how to get the material facts is through the areas of law. When you look at it yourself, if it's contract you are doing, you're teaching everyone contract, what area are you looking at? Is it offer? Is it acceptance? Is it constitution? Is it terms of contract? Is it voidable contract? You know that we're going to teach that in the other work as we come into the place, voidable contract, emphasize further. So on capacity of contract, and certainly on other aspects of mistake or contract misrepresentation, which are also good. So the first involves the question. Begin to ask questions from that case study, whether a main contract was ever formed between Gary and. So you can see that in this particular one, it's being raised as an issue, a question. So this involves traditional processors models of contract formation. So to you, you know that this is about contract formation. So the second involves question whether an option contract was formed whereby Gary promised to grant an option in favor of Martin. So the person, wherever we are raising issues. First, second issue, the main contract, we have material facts, which we've identified, the advertisement, Martin stating that he will give £4,500, Gary stating he will give this, Gary sending it to the other material facts. Then the main contract, you begin to signline it each other. And this is how it will usually look like. Material facts, identification of area law. So that material fact is where you are having to get your issues out. So the material fact, identifying the law, defining it, elaborating on it, and application which are usually arguments and counter arguments. Mind you, you couldn't have satisfied a case study without having arguments and counter arguments. You can't just have, it usually will not go one way, except on rare occasions that we would actually see. So that's one of the things that is mainly there. Then at the end of the day, you have to give a concluding advice. Concluding advice would be that from the first given, Martin should be advised that the agreement, the main contract, could only be construed into circumstances. You see how elaborate the advice is. First, in adopting the consensus model, we call construed overall arguments. However, this is not a popular or currently the prevalent approach by the court. So you have to make your concluding advice as practical as possible. Very, very important, as practical as possible, and you see what how it goes from there. Now, I want us to also now look into what we call some form of practical part, so that we see, because in the past we've given a number of assignments, And we just want to let us see one of them and see how it was addressed. I'm going to share my screen now so that we kind of get how this is usually addressed. So this is one of the assignments that have been given, the book 10 assignments given to another set before, and we look into that part of hire purchase. About 24th of November 2005, Wole Kola Wole entered into a hire purchase agreement with Lanre Adebodun, Nigeria Limited, Lanre, in respect of the Toyota, and for the sum of 1,600,000 naira, and the two copies of the hire purchase agreement were signed by both parties. However, Lanre, did not give Olowole Kolawole his own copy of the hire purchase agreement. And under the said agreement, a deposit of 100,000 naira was to be paid, for the balance in monthly installments. Hire purchase at the end of August, obviously, he paid a total of 1,240,000 naira, and in respect of which no receipts were issued to him by Larry. So sometime in September 2009, the said boss developed engine problem, the result of which Wole Kola Wole could not pay the installments, and for the months of September and October 2009. And obviously, Larry wanted to retrieve it. So what we look at is that this is the case study, and this was for one. Now let us see how Group 1 addressed this particular case study by seeing how we can open it. Let's see how Group 1 addressed it. We're sharing our screen here. So you can now see the way it is being addressed. The assignment advice to the parties. Now look at the background of the case, the introduction. On the introductory part is the way you can see the introduction. The introduction usually will give you like an overview of the topic itself. Because if you look at it, you notice that the topic there was about hire purchase. So that is where the introduction would be able to beam the searchlight on. You can see that it talks about the aspect of law, contract of hire purchase. It leaves citations because the moment you are giving your introduction, you cannot just do it by just stating the principles. You need to cite one or two cases to support you or some secondary sources define it. So we have introduction first, then we have the background. We're talking about the material facts because it helps you a lot because in this background, it's not for you to go and rewrite the entire thing. Don't be swayed by what you are seeing here. I usually tell the students that sometimes you don't need to do that. But in this case, we have all of it identified. The background, it gives you the material facts, which are actually relevant for the purpose of you trying to solve the legal issue. So we have the background, and we usually call it background and facts. But here, separated, because of time, we have to just make it into one. Then after that, you look at it as issues for determination. You notice that the first issue that was raised was whether there was a hire purchase agreement between Kola Wole and Lanre and another. And then the first thing was that let's look at the principle of hire purchase. You can see that it started just like how we were talking about it. It has now started that okay, the person has identified the issue, and now the principle of law has been defined. Okay, the principle of hire purchase is contained in all the laws of England, so it defines it under the issues. Each of that case study that we talked about then is being addressed here. So the first issue is whether there was a hire purchase agreement between Kola Wole, Lanre, and another. And the principle, so once you raise it, you have the principle of law being there. Then from there, you've been able to elaborate on that principle because everything is happening at the same time, simultaneously. Then from the above, you now begin to put your arguments, like you see, applying it to the facts of the case, that from those material facts, because each of those material facts you're identifying are likely to become issues on their own. You raise issues from them. So on the above case, it follows that the hire purchase agreement must have contained an option to purchase the price for which. So it's now the person is now applying it to the facts of the case. Also, the learned judge in the same case submitted for a document to qualify must be this. And we should also note that hire purchase is different from credit sale because in credit sale, the purchaser has this, and hence hire purchase must be valid before it can be enforced. Then he said, this is my advice to Kola Wole. So you can see that it is very, very important. I said that, okay, whether the other issue of whether Kola Wole can lay claim to the title to complete payment. I said the purpose of hire purchase might take ownership at the end of the term. So the principle of law is outlined first because the aim of this case study is to give you, apart from the issue of the knowledge, the understanding, and the practical application. Everything is combined into legal case study. That's what makes legal case studies very unique. So here we have the definition of the law, and the person goes ahead to now apply it accordingly, which we can see being detailed here. And make sure that all the relevant issues have been identified and being discussed appropriately, and then we now have a general conclusion. But remember that as you are doing your whatever, you raised an issue. Your issue was whether Kolawole was liable. You must be able to conclude that Kolawole, whether is he liable or not. So as you are doing it, as you are solving mathematics, you have your law defined properly, elaborated upon, applied to the facts of the case, where you have to, when necessary, you're making arguments and counter arguments. And from there, you now have a kind of a submission, which says, to which addresses that issue, that question you raised, whether this person is liable. And now, at the end of the day, you may now come to say the person is not liable, or the person is liable, or your answer might go two ways arguments, depending on the facts of the case. So let us go into another one that we have here. Let's see if we can share that. Because of how we are putting it together, we'll see how we can cover that. So we have that here. Let's see. Group assignment for group 10. So we look at the other part of it, which is legal case study. So it talks about stable design. At first, you can see that. So these are the case studies, and it usually tell you, it will say at the end of the day, advise. This one says what should you decide, but say advise the person. Sometimes you could say what should they call decide. So this is exactly the facts of the particular case. So let us now see how it was now identified. Because we now know the structure, and we are just going to see how we can just proceed with what we are doing, so that we don't waste so much time. So this is group 2 submission, addressing the other one we just looked at now. And what now happened was, it was like you see that it followed into introduction, background, arguments presented by each party. In fact, these are students of JHU addressing this. You see that when you read it, it's almost like you're seeing the lawyers writing. So you have introduction first. Like we said, it introduces you to the topic, not to the material facts, but it can make a mention of one or two material facts, but it won't anchor it more on the topic. Like if it is on contract now, maybe formation of a contract, it will talk about the formation of a contract legally, with citing cases and some other things there. Then it's now going to the background of the case, which we see the material facts. You can see how it's been demarcated, initial transactions, dispute over scrapers, delivery of scrapers, seizure of, then arguments presented by each party. Although this one, a lot of them actually go very, very far to see, and then you could see that the issues are now raised. Although we have some typographical errors there, which you should avoid from this day. So you can see that the case, a contract of hire purchase, is one under which an owner of goods lets them out. So it defines the law. This is the principle. It cites a case to support the law, which is Helby and Matthews, and it goes ahead to apply it. The basic element from the foregoing, a few points are worth noting about hire purchase transaction, the essential features of it. It's just that because of time, if you are doing an assignment like this, you can go very, very far. But for the exam purpose, after you define the law, elaborate on it, you go ahead and apply it. So the key facts supported the conclusion states this, and just remember that you raised an issue. The issue is there. So as you are proceeding to define the law and elaborate on it and apply it to the facts, arguments, and counter arguments, make sure that you answer that question that you just raised. Everything you are doing is to answer that question. Some people just forget it and they don't even give us the answer. So it's very important that you look at that. Then we have the other one that is there, and we also look at other aspects of it there. So then now but you see that and make sure you pay attention to typographical errors, so that you don't go into a situation where it is not, like conducive. So now we want to go as far as see how we can take all of them together. So let's look at the third one. In terms of the case study itself, the third one, so that we can now know that we are making progress. So we have legal case study 3, because there are 4 of them. They will now conclude with that final one. So this is the group 10 assignments, And this is legal case study 3. And for this, you can see that it talks about sometime in March 1997, Sir Samuel Ladele Okim Motors entered into a purchase agreement in respect of Toyota. And Samuel made a down payment of 140,000, total cost of 260,000. It was agreed that Samuel will liquidate the balance of 120,000. So as you are seeing all this, you are looking at what are the material facts here. And you will be able to know not everything is a material fact, but a lot of them might be material facts. You'll be looking at, be able to sift it out yourself. You'll be have your own, before you write in the answer sheet, just have where you can just be able to do this particular write-up and be sure. So it talks about the agent of Kim Motors forcefully taking the vehicle. So each problem question must have a kind of issue that is trying to solve most likely. So now let us look at this for group 3. So let us see how we can bring in the answer here so that we know how group 3 was able to address this. Obviously, we saw the other one that there were some number of issues there, but I believe that that one is, so that's why you need to look at it, because if you have typos there, it might give you affect one of the marks that you have. So now you see that with what we put there, you now have a part of the introduction, which says introduction, hire purchase, special consumer. You can see that this one is much more concise. Now, I used to tell people that the person that writes 2 pages of introduction and the person that writes this will probably get the similar marks. Obviously you have to add more references to it, but you don't need to go too far. You can see how this one went ahead to address the topic, hire purchase. Then the facts of the case, we started going to the material facts. This are in 1997, Mr. Samuel did this, entered into hire purchase. Then the analysis, the hire purchase agreement is a contract, owner of the chattel does this. Some actually might put in their own. That's why I said that what I enjoy very much about here is that students on their own go further to not just to put, they go further to actually apply it and adopt their own style within the parameters of what is supposed to be done. So this is exactly what we saw here. It was actually applied in the same context, and we had the application. You can see that the way it's been applied, according to the facts, there was no formal purchase agreement. It was after the legal side had been stated, the case in context, the application was now done. One of the reasons why this one is looking like this is that it was more like a review of a case. A review of a case that was being done. That, okay, let us review a live case. What should the judge decide? It was more like a very different type of case study. So they had to, it had a major issue, one major issue that they had to try. So with that, you see that they had to look into the case context itself, and they had to go into the application and go into the conclusion. I want us to go into the final part of it, the final part, which we are going to share. And this is looking at, for group 4. Group 4 looks at the case of Ajabe, which he bought a Toyota from Idowu, and on a credit sale of 250,000, for which he made initial payments, and obviously he defaulted. That was one of the facts of the case. I want us to see, for the last part, how this thing was addressed, by one of the students here for group 4, which I think it was really an amazing one to see how they actually addressed this. So let's see. So we looked at it, and you notice that they had to stay within the parameters of the word count. If the assignment gives you number of word count, you have to ensure that you keep that in mind. So here we have the table of contents, which says, you could see that this is usually the structure of what we see there. If you look at the elements, you see that I gave an example of how you address it. You have the introduction, you have the brief statement of facts, issues for determination, argument, conclusion, list of authorities. So the introduction, as you can see, the instant case is to determine the transaction between Jagbe and the plaintiff and the Dowu defendant is either a credit sale. So what the person did was summarize the main issue in the case in just one sentence. Then went ahead to start talking about the topic itself. So because it's through the summary of the main issue of the instant case that you can now get that part from it. So that's what it actually did here. And so according to Professor Akonki, so he went into secondary sources, commercial law in Nigeria, hire purchase agreement is a contract of hire coupled with the option to purchase and the first judicial recognition of hire purchase contract was by House of Lords in the case of LB and Matthew. So you can see that they are now going into the topic. So then, and they're also referencing to number of the Hire Purchase Act, Section 20 defines as this, just like how you do an article and you have to do the introduction first. Then you now go into the background and facts of the case. So why I made this one the last one to show you how just the structure, we saw a number of answers, but some errors in it. Some were typographical, some were structural errors. But this one really, because this one we actually got it one of the highest score in this. So the background and facts of the case, you can see that it stated here, the material facts of that actually defines the case. You can see it being outlined there. And then just giving you a breakdown, just like the facts are. This one is very straightforward because you're just getting the material facts. Then for the issues for determination, you can see that it's been outlined whether the transaction between them is a hire purchase agreement, whether the sale was illegal and irregular and unlawful. So you can see the issues. So now, from the issues now, we now have the arguments. The arguments, okay, whether the transaction. So you are now arguing each of those issues. Mind you, when you are looking at case studies, each of the paragraphs are likely to have at least one issue. So just be going through them sentence by sentence. Each of them, when you read it, don't just you rush to the arguments. When you read it and you're satisfied, you can now go further. Now, so the arguments, whether the transaction is, you can now see that there is the definition of the law. There's an elaboration of it, of the proposition. And we now have it. Okay, now after that has been defined, that's why I really love what happened here in this particular instance. This was one of the best papers I actually looked at and rated well because it defined it. It now went ahead to say, in this case, there are two reasons why the court should conclude transaction is not the hire purchase. Because the question was, what should the court conclude? It was, then you see that the application of the law is now being done here. Absence of option of purchase. You could see that the way it's been applied from the facts, there was no provision in the agreement. For them, the option to purchase was not there. Absence of the option to purchase the key characteristics of a hire purchase agreement. Notice how they are applying it. Notice how the definition of the law and the provision for the argument is not, it's actually sized up in terms of the number of space being used. Some people will define it in 3 lines and the application has to be elaborate. So notice how in Nigerian law requirement is this, and then the application is being done as it's supposed to. So the structure on its own, and then you're going to know written agreement. And he went ahead to say, by considering the similar factors and legal principles determined, the transaction between the who did not meet the criteria of hire purchase. Notice how they went back to the issue, whether or not the transaction is a hire purchase agreement. So after all the arguments, after the presentation of the law, the arguments in terms of application, you see that by considering similar factors and the legal principles and all what they've argued here, they can now conclude the way they did. There is another issue again, whether the sale of the Toyota is illegal, and they establish the law first, because that's why you are doing law. Establish the law that has established the agreement between the both parties, not a hire purchase or a credit. They went back to the first issue because the first issue linked to here, but they went to define the law, Section 38 of the Sale of Goods Act, and you now went into the application of the factual part, putting the material facts of the case law that based on the foregoing, unpaid sellers is defined as this, and then they went ahead to apply it and say Section 57 that does the contract not being a hire purchase agreement with a credit sale agreement entitles, and you see how factual it is. Then we have the conclusion that gives the advice proper itself, and that is exactly what happens. The general, this general specific advice being given, the references and the statutes. That's exactly what how you address that aspect of case law. It's very, very straightforward. So we expect everyone to attempt those questions in the exam, in the assignment that we've been given in the LMS. So because those are formative, we'll give you comprehensive feedback, even in addition to this. But this is just to let you know the structure, so that the moment you're answering it, it's very easy for you to know that okay, this is how it is to be answered. So with that, I really thank you very much for being able to listen to this and watch the video in terms of how to address legal case studies. So what are you going to do now? let's see how you are able to implement this in your assignment. It's very key to be able to do that. It gives you really, a lot of an edge in terms of being able to address things legally. Because when you are in your own your office and you're doing certain things, you will be able to know how to give a proper legal advice. Because some people think that legal advice is just supposed to put it down, right? No, there's a structure for that, and that's exactly what we're telling you now. That's why GHU is the place to be. It's not just to give you the work to do, it's also to guide you through the work and ensure that you actually do it right. With that note, thank you very, very much.